Picture this, you're in a crowd, chanting for change. The energy is high, banners wave, voices rise, police line the perimeter, watching. You're exercising your constitutional right to protest until a bottle shatters a window and chaos erupts. When does a peaceful protest turn into an unlawful riot? And what can the government lawfully do about it? Today, we break down those answers. We offer a handy checklist of protest rights you should know about. At the end of the video, we examine appropriate countermeasures government is allowed to take. By the way, this is part 2 in this series. This video stands on its own, but be sure to check out the first video for more commentary about the right to protest if you're interested. Under the First Amendment, Americans have the right to peaceably assemble. Emphasis on peaceably. Peaceful protests, even loud and passionate ones, are protected by the Constitution. But no one has the right to assemble for violence. So what flips the switch from a protest to a riot? Legally, it comes down to violence and danger. Generally, a gathering becomes a riot if, 1, it involves a group, usually 3 or more people. 2, those people engage in acts of violence or immediate threats of violence. And 3, the violence poses a clear and present danger of harm to people or property. In plain terms, a protest stays a protest as long as it's nonviolent. Once people start breaking windows, setting fires, throwing punches, or threatening to do that, it crosses into riot territory. Importantly, as I've covered before, passionate speech, even if it's angry or controversial, is not a riot. The Supreme Court in Brandenburg v. Ohio in 1969 ruled that even deeply offensive speech is protected unless it is intended and likely to incite imminent lawless action. Determining the fine lines between riots and contentious protests is admittedly difficult. In Feiner v. New York from 1951, the Supreme Court faced the difficult question of exactly when heated speech at a protest crosses into unlawful incitement. Irving Feiner was speaking on a street corner in Syracuse, criticizing political figures and encouraging listeners to fight for equal rights. He called President Truman a bum and used confrontational language in the faces of onlookers who were growing very agitated. His words drew an angry, growing crowd. Police, fearing imminent violence, asked Feiner multiple times to stop speaking. When he refused, he was arrested for disturbing the peace. In a tight 6-3 decision, the Supreme Court upheld Feiner's conviction, ruling that the police had the legitimate authority to intervene because they reasonably believed violence was about to erupt. However, in a strong dissent, Justice Hugo Black, one of my favorite justices, warned about the dangers of silencing controversial speech under the guise of public safety, emphasizing that speech should not be suppressed just because it stirs listeners. That line of judicial reasoning still exists, so it's helpful to have skilled attorneys advising when dealing with some of the most contentious protests. Under the usual test, yelling for justice is one thing, inciting the crowd to immediately smash things is another, and a lot hangs in between. Real-world examples make the point. In the summer of 2020, millions marched after George Floyd's death. Most demonstrations were peaceful, but in cities like Los Angeles, some protests turned violent. Individuals smashed store windows, police cars were vandalized, and an officer was attacked. At that moment, what had become a lawful protest became a riot in the eyes of the law. On the other side of the political spectrum, January 6, 2021, began as a rally outside of the Capitol. It became a riot the instant crowds broke past barricades and stormed the Capitol with force. The law doesn't care why you're protesting, it cares how. For or against any cause, violence means a riot, and peace means protest. When a protest stays peaceful, government officials must tread carefully. The Constitution doesn't let them shut down a protest just because it's inconvenient or unpopular. Government can enforce time, place, and manner restrictions for public safety. For example, cities often require permits for large marches or limit loud demonstrations to certain hours. These rules are legal so long as they're content neutral and leave open other ways for people to get their message out. A 1941 Supreme Court case, Cox v. New Hampshire, upheld this principle, recognizing that officials can impose reasonable limits on when and where protests occur, as long as they're applied fairly and serve a significant public interest, like safety. Curfews are one such tool. During intense unrest, a city leader may declare a temporary curfew, requiring everyone, including protesters, to clear the streets by a certain time. Are curfews constitutional? Courts mostly say yes, if used properly. In New York City, after some 2020 protests escalated into nighttime looting and clashes, the city imposed a one-week curfew. A federal appeals court later upheld that curfew as a legitimate public safety measure, noting it was a temporary, last resort response to escalating violence, not a blanket ban on speech. The curfew applied to everyone, regardless of viewpoint, and was lifted as soon as the order was restored. So if your city announces a curfew amid unrest, know that it's generally lawful in a real emergency. Violating a lawful curfew can lead to arrest, so staying aware of these orders is crucial for protesters. What about more direct police action, like officers in riot gear, tear gas, pepper spray, flashbangs, mass arrests? The Constitution permits law enforcement to use reasonable force to keep the peace, but only when necessary. Crucially, force should be a last resort. The constitutional shorthand for this: police shouldn't disperse a peaceful gathering unless there's a clear and present danger of a riot or safety threat. If an assembly remains nonviolent, indiscriminate use of tear gas, rubber bullets, or batons could violate protesters' First Amendment rights and sometimes Fourth Amendment rights against excessive force. In fact, during the 2020 racial justice protests, some federal courts stepped in to stop police overreach. Judges in Denver, Portland, and Seattle issued restraining orders prohibiting police from using tear gas and projectiles against peaceful protesters. These courts recognize that you can't trample constitutional rights under the guise of crowd control when the crowd isn't threatening anyone. On the other hand, when protests do become violent, police have broader authority to intervene. If people are actively rioting, throwing objects, fighting, setting fires, officers can lawfully order the crowd to disperse. Once an unlawful assembly is declared, a formal police announcement that the gathering is no longer lawful due to violence or danger, protesters must be given a chance to leave before force is used. Those who refuse can be arrested. And if rioters attack police or others, the use of tear gas, pepper spray, other non-lethal force to regain control is generally permissible. For example, during the January 6th Capitol riot, law enforcement deployed tear gas and flashbang grenades to push back the mob, and Washington, D.C. imposed a 6 p.m. citywide curfew to help quell the violence. Similarly, in Minneapolis in May of 2020, when protests over George Floyd's murder evolved into a dangerous situation with arson and looting, the governor activated the National Guard to restore order. The rule here is that any counterforce must be proportionate and targeted at stopping violence, not at suppressing the protest message. Know your rights and their limits. If you're heading to a protest, remember, keep it peaceful if you want full constitutional protection. The moment rocks or fists fly, that protection evaporates and criminal laws take over. Don't let provocateurs lure you into unlawful conduct. It could mean arrest or worse. If someone near you turns violent, distance yourself. Document what you see. Remember that smartphones are your friends, but don't get mistaken for a part of the riot. Likewise, know the orders on the ground. If police declare an unlawful assembly or announce a curfew, take it seriously. Legally, they must give you a clear way and enough time to disperse. Use that chance. It's not cowardice, it's smart. You can always regroup to protest another day. Staying past a valid dispersal order not only risks arrest, it can also risk injury once the tear gas and batons come out. No cause is served by getting hurt for no good reason. Also, be aware of your surroundings and your fellow demonstrators. Large protests can attract counter-protesters or agitators. Violence from any side can trigger a crackdown on everyone present. By staying peaceful and encouraging those around you to do the same, you help keep the protest on the right side of the law and safer for all. America's commitment to free speech and assembly is strong enough to protect passionate, loud, and unpopular protests. But it draws a bright line at violence. Understanding this distinction empowers you. It means you can raise your voice without losing your rights, so long as you do it peacefully. And it means you'll recognize when authorities are acting within their legal power versus when they're overstepping, like cracking down on peaceful dissent. The Constitution cuts both ways. It shields the protester on the sidewalk with a sign, and it sanctions the officer who stops a rioter from throwing a brick. Knowing how a protest differs from a riot and knowing what responses the government can lawfully take gives you the tools to protest with passion and prudence. So stay safe, know the line, and let your voice be heard lawfully. I'm Benjamin Barr, and I'm thrilled that you were with us today. My job as a constitutional litigator with a lifetime of experience is to give you the tools necessary to solve today's constitutional puzzles. I hope you'll like and subscribe and join us next week as we tackle yet another constitutional controversy.